Okay, this is People of the State of Michigan versus Jordan Kronk, docket number 20-292FC. And Mr. Kronk, before we go further, could you just confirm for me that you agree with doing the sentencing this way, with you in the jail instead of in the courtroom?
Yeah, this is fine.
Thank you. Mr. Kronk, you were convicted of larceny from a motor vehicle. That is a felony, and also felonious assault, also a felony, because the prosecutor's proceeding against you as a habitual second offender. It makes the maximum penalty of the larceny from a motor vehicle up to 7.5 years in prison, and on the felonious assault up to 6 years in prison. You have the right to be represented by an attorney. You are represented by Mr. Silverthorne. Mr. Silverthorne, have you had a chance to go through the pre-sentence report with your client?
Did that earlier today by Polycom, Your Honor.
Okay, and do you have any additions, deletions, or corrections?
One, but I think the court has already caught it because I was on the email thread regarding the habitual third, that it should actually be an habitual second.
Yes, and I should say, let me help you out here. So I noticed that earlier, and I emailed the attorneys, and they confirmed it was a habitual second, which is what I thought. And so I changed on the cover sheet in the box, current convictions. Obviously, I changed it from third to second offender, and I changed the maximum penalty from 10 to 7.5, from 8 to 6. Then under plea agreement, I changed it to second habitual offender. And then under evaluation and plan, paragraph 3, I changed it to habitual second offender. And then it got a little easier than I thought it was going to be, because the only other place I had to change it was on the BIR. The current offense, I changed it, both the reference to third offender, which I made second, and the maximum penalties, which I changed as I've already indicated. And then on the sentencing guidelines, I changed it to second habitual instead of third. I didn't make the other change to the guidelines that it would require, because I wanted to see first if either of you had any other objections to the scoring. So did you have any other objections first or changes first, Mr. Silverthorne, to the report?
Under the plea,
did I get them all?
it currently reads that 20-503 FH shall be dismissed, period, defendant to pay restitution owed. With the agreement that we put on the record, from my notes and recollection, was that he would be paying $495.51 in the other case. We didn't mention the person's name, but we did mention 20-503 FH. I think that's relevant because of the recommendation for restitution in the current file that I don't think was made part of the plea bargain. At least my notes don't indicate that it was.
I'm not sure I followed you. Are you saying the restitution is owed actually on this file?
The restitution should be owed in 20-503, the dismissed case.
Okay.
Mentioned a specific dollar amount of $495.51 that should appear under the plea agreement there on the first page. It just says defendant to pay restitution owed.
Oh, okay. So I'll just add in the amount of $495.51.
Yeah, as to that file only. That's what we mean, Dwayne.
That's correct.
That's not the total restitution for the entire case, but as to that file, we had that specific amount, correct?
Correct.
Okay.
Got it. And any other changes, Mr. Silverthorne?
No, Your Honor.
Do you have any objections to the scoring of the guidelines, other than we're going to have to change the maximum because they, or the high end of the minimum range, because they did it based on habitual third?
No, with those changes, the guidelines, the actual scoring itself should be fine.
Okay, so Ms. Allen, did you have any corrections to the report or objections to scoring?
No, Your Honor, other than, like we said, changing the high end. I did
Right.
request, because initially we only got the larceny from a motor vehicle ones. And although that is the higher one, it was just a weird circumstance. The guidelines were higher for the felonious assault, which is why I requested it just be part of this file. But that is
Right.
something I emailed about this morning.
Right, so they sent both now, but,
Yeah.
so let's see, F, I'm looking at the, well, let's start with, I'm looking at the larceny from a motor vehicle, it's F3, that's, class G. Therefore, as a habitual second offender, it should be 7 to 28.
That's
Correct
correct.
me if I'm wrong. And on the other one, assault with a dangerous weapon, that is a class F. And he's F2. As a habitual second offender, that should be 12 to 30. Did I get that right?
Yes, Your Honor.
Yes, Your Honor.
Okay. And although after all of that, I acknowledge that there is a Killebrew agreement to a fixed 24-month minimum sentence in MDOC. And let's see. Then, is there a victim who wishes to be heard? And there is a gentleman here in the courtroom. Sir, could you come up to the podium, please? And to start, could you please state and spell your name?
My name is Michael Javid, Michael. Last name is Djavid.
D.
Jav as a Victor, ID.
Thank you very much. Go right ahead. With whatever you wanted to say.
I'm just hoping whatever comes out of this one, the time you get out, you will be a better member to our society and change your life for good and on. Life will be much better for you and for us.
Great.
That's
Thank
all.
you.
Thank you.
Thank you very much for coming today and making your
I
comments.
appreciate it.
Okay, and did the people wish to be heard?
Your Honor, only to reiterate, I've spoken with Mr. Javid throughout this case, and he has said that all along. This has obviously caused him distress with his work and having to go through this during this time. And he has been that, that's been his mindset all along. And I think that the plea agreement we've come to is fair based on the fact that the defendant is on parole and he's going to have to deal with that issue as well. And we ask the court to follow it. Thank you.
All right, thank you. And Mr. Silverthorne?
In terms of allocution, I've met with Mr. Cronk on several occasions, actually more than several occasions. He's good with tools. He has skills. In fact, he said getting work was never a problem for him. He actually had an extensive work history. The problem is it just never paid what his drug needs caused, the primary of which is methamphetamine. So I don't know what kind of recommendation the court would make to the MDOC, but if he could get a handle in the next 2 years or whatever amount of time, because technically he's still in the MDOC right now, if he could get a handle on his drug problem, he's bright, he communicates, he has a lot of skills. He'll do fine feeding himself, but he won't be fine if he has to feed a drug habit. In terms of following the recommendation, I have a problem with the restitution to Mr. Javid. It wasn't made part of the bargain, but I think the court inherently can order restitution, but the amount is troubling. And I looked at the information provided by Mr. Javid. It was either 40. He initially said that 25 cars had been hit, but he said don't hold him to that. And then he's provided information that said 40 to 50 cars are tampered with. And he said that the converters taken would be 500 to 600 new. So we have a range, a top range of 30,000. That would be, let's say we go to the max at 50 cars are hit, and we put $600 for a new catalytic converter, and I'll get back to that in a minute. Or we go to the lower range of 40 cars converters were taken at the $500 new range, and that's 20,000. Well, that's a lot. That's a really far away from 103,813 and 43. And to point out, this is not a car lot with new cars or even used cars. This is colloquially known as, it's a parts place. It's a junkyard. They take old vehicles and they take parts off them and they bone them out. That's a term of art. They convert them to parts. A decent business. And so the prices that was put in here is that 500 to 600 new for a converter, and these are used converters. So I don't begrudge him getting what he's out. I just think that we need some documentation as to what the amount is. And like I said, by his own figures, it's way away from the 103,000. I mean, like I said, his figures would show anywhere from 20 to 30,000 for new catalytic converters. So again, I hate making these arguments because he's out. This is his livelihood. I feel bad for it. But then again, let's have a realistic figure of what's owed, and let's have some documentation of what's owed in this case. And that being said, I don't need to go on further. I told Mr. Cronk this would be a short sentencing because as long as the court will adhere with the Killer Group plea, any uncertainty he has is with his pending case in Clinton County and with whatever kind of additional time, if any, that the parole board will give him on the case for which he's on parole. So I'm through, Your Honor.
Thank you. Ms. Allen, I know I already asked you, but just on this issue now, he's raised a restitution. Did you want to be heard?
Well, Your Honor, we have an 83-page document from the victim that lists the replacements and then also the cost that it takes for labor to replace a catalytic converter. It's not just that it was stolen, that it was removed from a vehicle and then needs to be replaced and someone has to replace it. And based on Mr. Silverthorne's face, I don't know if he doesn't have that. What I would propose is this: if we can leave, I've done this a couple times, leave it open, let Mr. Silverthorne and I make sure he has everything I have. And then if we can do, we've done either set it for a hearing or we can prepare a stipulation order for the restitution amount we can agree on. We've done that before on big cases like this. If the court would allow that, that would be my preference to make sure.
Okay, great, thank you. I just wanted to clarify that. Then, Mr. Cronk, did you wish to say anything?
Yeah, let's keep it short and sweet. First of all, as for the victim, I never meant to harm him, bring any assault to him. Like I said, I was in the back of a junkyard. I have a drug problem. I was doing it to obtain money. So I'm sorry for the victim for even coming in contact with him. That was never the case. Two, I don't think I should be responsible for all these other vehicles in that junkyard. I take responsibility for the one I was going after, yes. For the rest of them, I don't think I should be responsible for those. That being said, I'm sorry to the court for what I did, and like I said, I'm sorry to the victim for having even assault brought upon him. So that's all I got to say.
All right, thank you. Well, I'm going to have to leave the issue of restitution open. I think it's a little absurd to say that you only have responsibility for the one that you were caught on. I think it's clear that this was a course of conduct that is much broader than just one catalytic converter. And I think it's only fair to acknowledge that this gentleman who's here in court today has had a significant economic impact because of that course of conduct. But I will leave it open and order that you pay $130 to the Crime Victims Fund, $136 in state costs, and restitution to be determined. And on count one, you are committed, costs in the amount of $500 based on the State Court Administrative Office calculated average cost of a criminal case in Ingham County. And on count one, you are committed to the custody of the Michigan Department of Corrections for a period not less than 24 months nor more than 90 months with 0 credit for days served. And on count 4, you are committed to the custody of the Michigan Department of Corrections for not less than 24 months nor more than 72 months with 0 credit for days served. These two sentences for count 1 and count 4 run at the same time as each other, but they run consecutively to the sentence that you are serving, that you were on parole for. And Mr. Kronk, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to help you. If you're making a request for an attorney to go forward with an appeal, you have to make it with that request within 42 days of today's date. There is a form that you use for that. We will send it to you. You should just be aware that the time of 42 days starts running from today's date. And do you have any questions, Mr. Kronk?
I just have one. So my time doesn't start on this until after the parole board makes its decision?
Yeah,
There's my time.
whatever sentence you were serving or that you will serve for the parole, by law, this has to start running after that.
Okay. So it's not really a fixed date then, it's a fixed date after I get sentenced or determine whatever it is with them? Then a
Correct.
fixed date?
Correct.
Oh,
My
all right.
sentence is fixed 24 months, just like the plea agreement, the sentence agreement, but that doesn't take into account parole.
Okay.
Okay? You're all
Yep.
set then? And you can tell them there at the jail your hearing is over, and good luck.
All right. I'm all done.
Thank you, Mayor.
Thank you.
Have a great day.
Thank you for coming.
Be safe.
Good day, Your Honor.